So the feds are basically getting ready to ramp up, and they say, we ain't stopping nothing. Let's get into it. That's your cast of characters already. And y'all can see Esley, you see, he got first assistant United States. So you ain't even a big dog. They put him as assistant. Go back in those old ones, you know exactly what we're talking about. United States American plaintiff versus Durk Banks and the defendants. So it says government's response to defendants' joint objections to court's November 14th, 2025 scheduling order and unsupported requests to stay proceedings. The plaintiff, United States, you already know all that crap. And this basically says this filing is based upon the attached memorandum of points and authorities, the files and records in this case, and such further evidence and argument as the court may permit, dated November 17th, 2025. Let's get to it. Memorandum of points and authorities. Following defendants filing their motion to dismiss this murder case and disqualify all judges and prosecutors in this district, docket number 290, this court entered a scheduling order that made clear the previously calendared motions would be heard as scheduled on November 18, 2025. On Saturday, defendants filed objections to the scheduling order, which, among other things, seeks to stay substantive proceedings. Pending resolution of their motion, docket number 295 at 1. Defendants failed to cite authority that in any way justifies staying this murder case. In fact, defendants cannot meet any of the 4 factors necessary to warrant a stay, specifically proof they are likely to succeed on the merits of the motion. Nah, they actually kind of did because they cited a source in Oregon that was similar to this. So y'all lying right there, but whatever. The extraordinary remedy of a stay in this criminal proceeding would deprive the public and the murder victim's family of a speedy trial. The request should be denied. Now, unless I'm misreading it and they're saying you guys can't cite an actual law or a ruling that says when y'all file that motion that we had to stay the proceedings, that's the only thing that I can think of that makes the most sense. Because saying that, oh, y'all don't have a case when they're literally citing the case in Oregon, that doesn't make sense. But the feds are full of shit. But it's funny because if it was the feds and they wanted something done, the courts would stop their proceedings. So it is what it is on that part. Let's continue on. Roll it. The court should reject defendants' claim on the merits and deny their request for a stay. Defendants cannot justify a stay under the 4 traditional stay factors set forth by the Supreme Court. Courts routinely apply these factors in criminal cases. Stay a compassionate release order. Then they got some say stay a judgment pending state court proceedings. We go down. The party requesting a stay bears the burden of showing that the circumstances justify an exercise of that discretion. To do so, the requested party must satisfy 4 factors. 1, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether issuance of the stay will substantively injure the other parties interested in the proceedings. And 4, where the public interest lies. The first 2 factors of the traditional standard are the most critical. Only after the applicant satisfies the first 2 factors should courts assess the harm to the opposing parties and weighing the public interest. Then it says, A, defendant have not made a strong showing of likelihood of success on the merits. I disagree completely, but whatever. Defendants cannot show a likelihood of success on the merits because neither this court nor any other judge in the district should recuse under 28 U.S.C. 455. The law is clear that threats, and then we could go into it, but it's going to be a long ass video if I do it. So the law is clear that threats or other attempts to intimidate the judge do not ordinarily require the recusal under 455, United States versus Holland. Indeed, judges have rejected recusal even after receiving threats from defendants far more serious than the voicemails at issue here. But that's not what they're arguing, but whatever. Threatening voicemails on a judge's home answering machine, government's initial response to defendant's motion, recusal under 455 requires an objective and subjective analysis. Under the objective standard, a judge must recuse in any case where his impartiality might reasonably be questioned. This is a fact-specific inquiry that should be guided by the circumstances of the specific claim. The substantive inquiry requires the judge to determine whether he can be truly impartial when trying a case. ID at 915. Applying those factors here, there is no objective basis for this court to recuse itself. The evidence shows the threatening conduct at issue was done by third parties, not the defendants in this case. At least y'all can acknowledge that. The United States Marshal Service informed the court about the 4 voicemails left to the magistrate judge, and it is unclear if the court had any knowledge of the threat to the AUSA. Moreover, the content of threats leave no doubt the phone calls were designed to influence and manipulate proceedings in the case. CEG Holland 519 F3D at 915. But hold on, let me get a little bit more, and then I'll tell you what the hell they lying about. Manipulate assignment of judge would subvert our process, undermine our emotions of fair play and justice, and damage the public's perception of the judiciary. Following defendant's reasoning, anytime a district magistrate judge in a district is threatened, regardless of the circumstances of the threat, defendants will be allowed to disqualify all judges in the district prior to the assigned judge even considering the matter. This is plainly contrary to 455. The government is aware of no case that would support such an outcome, and defendants have not cited one. So the feds are obviously forgetting that they're talking about, bruh, all the judges who denied bail. And then y'all just admitted, oh, yeah, the marshal said that it was 4 voicemails left. Y'all actually damn near said that didn't happen. And then when you did admit that it did happen, y'all didn't come out and say, hey, Drew, yo, there were some voicemails left on the judges, whatever the hell and all this shit, bruh. Just letting y'all know it's an active investigation. Y'all went the ex parte route. Then turn around and say, well, you know what? That actually wasn't from the defendants. That was some third party stuff. Basically trying to call them fans. You don't know who the hell that was from. How do we know that ain't from y'all? So for y'all to basically try to already say these are fans, how do you know? How thorough was this investigation? You don't know because you're lying. Y'all didn't do shit. Y'all didn't do a damn thing. Y'all probably ignored it. Y'all probably listened to the voices, and then next thing you know, reported it, and that was that. I doubt highly that the feds even really looked into it. They probably heard some suburban-ass kid who sound like he got helium in his goddamn throat, and y'all looking, listening, and laughing like, you ain't serious. We'll smack you in your forehead. Knock it off. Ain't nobody finna be threatened by y'all. So I don't believe shit the feds are saying because they keep on saying, oh, well, they haven't actually cited the law. Yeah, they did. That's why y'all can't address the bail part. Now, they may down a little bit. I don't know. But let's continue on reading. Defendants cannot show irreparable harm. Defendants have failed to show they will be irreparably harmed absent a stay of these proceedings. Proceeding with the November 18 hearing would not create an appearance of impropriety that cannot be remedied later. Since the voicemails left for the magistrate judge do not create an objective appearance of bias vis-a-vis the court. Moreover, mere injuries, however substantial in terms of money, time, and energy necessarily expended in the absence of a stay, are not enough. The possibility that adequate compensatory or other corrective relief will be available at a later date in the ordinary course of litigation weighs heavily against a claim of irreparable harm. See Sampson versus Murray. Indeed, defendants failed to articulate any prejudice from proceeding with tomorrow's hearing date. The hearing has been set for months, and the motions the court is set to evaluate have been fully briefed. If that's the case, then why ain't y'all let this stuff be known sooner? Why let it be known this late in the game? That's the part where the state will substantively injure the government and is not in the public interest. They're in jail, locked up. I mean, come on, bro. Finally, the defendants cannot satisfy the third and fourth factors which merge when the government is the opposing party. An indefinite stay of this criminal trial pending the resolution of defendant's motion does not serve the compelling interest in prompt trials. That is a societal interest which exists separate from and at times in opposition to the interests of the accused. Flanagan versus United States. Encouragement of delay is fatal to the vindication of criminal law. Denying stay pending appeal where issuance of an indefinite stay would deprive the public of a speedy trial on the merits because a prolonged delay would harm the interests of the victim's family, the government, and the public. In a speedy trial, this court should reject defendant's stay request. Defendant's filing does not cite, what the hell is this, Incan or any other law justifying a stay. The case law defendants rely on does not justify a stay of all proceedings. In fact, it offers further support that this court should resolve the recusal issue. Defendants rely on United States versus Azhokar. I don't know, yeah. Which involved a defendant seeking recusal based on the judge's personal bias or prejudice under 28 U.S.C. 144. Unlike the statute applicable here, includes explicit language that the judge shall proceed no further if the moving party submits a timely and sufficient affidavit establishing the judge's bias or prejudice, even though the Ninth Circuit categorically rejected the defendant's argument that the district judge's failure to assign a Section 144 motion to another trial judge for a hearing was error. Azhokar, quoting Berger versus United States, noting this contention is without merit, explaining that a judge against whom an affidavit of bias is filed may pass on its legal sufficiency because, inter alia, the reasons and facts for the belief the litigant entertains are an essential part of the affidavit and must give fair support to the charge of a bent of mind that may prevent or impede impartiality of judgment. The remaining cases defendants rely on similarly, have no bearing on issues before this court, much less mandate that this court stay these proceedings until resolving all issues raised in defendant's motion to dismiss/disqualify. See Cochran versus U.S. Exec Common, and then addressing question presented of whether a provision of the Securities Exchange Act of 1934 implicitly strips federal district courts of subject matter jurisdiction to a hearing structural constitutional claims. Barksdale versus Emmerich, civil case involving post-judgment recusal motion claiming district judge was personally acquainted with two defendants and that within the last week plaintiff's counsel has learned that the son of a defendant is a law clerk of this court. Cleaned up. Conclusion. The government respectfully requests this court deny defendant's motion on the merits in their request for a stay of these proceedings. We'll see, bro. Ultimately, I don't think the judge is going to recuse himself because of the simple fact of the matter, you don't have to. What Drew and them are trying to do is trying to get the judge to essentially see it as they see it. Judge, you and your people got threatened. You think that wouldn't subconsciously bear in the back of your mind? You think that all these rulings and these cats basically being denied bond, you don't think that wasn't in there? Even in they filing in this one, they're still acting like Durk and them are basically guilty of other crimes that have not been brought forth against them, not prosecuted against them, all off a hearsay of what confidential witnesses say. So they're basically, this is the feds, they're banking all of this shit on quote unquote snitches, cooperating witnesses, confidential informants, whatever you want to call them. That's what this whole case is about as far as it involving Durk. I think what happened was somebody, and they said it was facing a life sentence, knew some details about this stuff, and basically was like, shit, ain't Durk involved with it too? Here's these text messages right here. Look, man, listen, this is actually what this means. This means this right here. This means this right here. I'm telling y'all what I know. I can actually tell you how they did the whole murder of Quando Rondo's cousin, even though they were supposed to kill Quando Rondo. I can tell you where they was at and all of these things. And I think that's what ultimately happened. I think whoever the snitches are knew about the murder, but they knew you need that big fish. It's crazy the parallels that it draws to the Young Thug trial because one, and this is the biggest one, you're not seeing too many crimes committed by Lil Durk at all once we hear about everything that comes out. So when you're dealing with this shit, when they got to tell the truth, which they won't, you just got to sit back and go, all it is a belief of character. Because even when the feds try to say the fight shit, you notice how they stop saying it? You notice how they're no longer talking about fights anymore? They want to go ahead and keep up with all of this shit. They no longer bring up and defendant Durk Banks was actually trying to escape and flee the country and all of this shit the day of his arrest. They don't bring that up anymore. So The whole charge of a guilty mind and all of this stuff and everything, no, that's out. They're still trying to push an old-ass song that doesn't even make sense as far as any bearing on this case at all. Then, if you really want to, when they try to paint it, if I'm Drew, I know Durk gonna be pissed off to hear, but I'm gonna say we gotta bring in some of this other shit. When you say, I don't want the nigga, I want the one that I paid for. Why is that important? Because if they're saying this shit, then why wasn't Quando Rondo shot at more times over the years? Where's all those shooters at? If they're willing to get on a goddamn plane at the snap of a finger, you don't think that they wouldn't have done that before? It's not like they solved this case overnight. Somebody had to run and tell. So, nah, bruh. But the feds are going to win this. The stay is going to be there because the judges ain't finna do it. It would be shocking. It would be the right thing to do. It would. It'd definitely be the right thing to do, but they're not going to do that shit because they don't care. They already didn't want this to go forward, but when y'all drop damn near 10 terabytes worth of bullshit, there you go. So now not only do we have to sift through terabytes of information, which I can damn near guarantee probably a terabyte and a half was BS, and now you're finding out, oh, bro, they trying to drown us in paperwork. Not only are they trying to drown us in paperwork, they're trying to tell us you get through this paperwork in 2 months. What the hell? Nah, bro. And on top of that, it's a RICO, so now I had to look at the other freaking lawyer's schedule, and then I had to wait on them. They failed to mention that part. Whenever these whenever these lawyers had to had to get together, they had to clear schedules. Subscribe, turn on the bells to notify, share to keep your people aware. When one of these, we actually had 100 people drop out of the contention. It's looking good for literally 200 people right now, bro. So make sure you comment, make sure you like every video, and you share every video, and be an active subscriber. But other than that, click right here and see how I believe 6ix9ine actually lied on his home invasion. Crazy shit going on. But hey, I'll catch y'all in the next one.